Hello and welcome to today's National Eviction Team webinar on the removal of protesters and demonstrators. Before we get going, just some housekeeping. Just want to make sure everyone can hear correctly. So you have a little question box on your screen. Just put in yes or no if you can hear me correctly. And if none of you say yes, then there we go. Got 7 or 8 of you already saying yes. Brilliant. Good start. Whilst I have your attention at the question box, you can use the question box throughout to ask questions that we will spend 5 or 10 minutes, depending on how we get at the end, where we'll answer your questions. Also, whilst we're there, if you've got more than one of you listening, could you just let us know in the questions box how many of you are there in attendance? A little technical tour. You'll have your handouts in the box below the questions. They'll also be emailed out to you at the end. Quick disclaimer, please do treat the contents of this webinar as food for thought, but don't take any actions based on its content unless you've taken legal advice. The speakers cannot accept any responsibility for errors or inaccuracies, loss or damage unless we have given you personally specific advice relating to a matter about which you have given us full background details. The aim of today's webinar is to provide sufficient understanding to commercial and statutory authority landlords and landowners of how to evict squatters, trespassers, activists or protesters from property and land. To consider what practical and regulatory matters will affect regaining vacant possession and plan how to deal with such issues that arise. To consider, predict and mitigate commercial and reputational risks, and to understand what compliance and service standards your chosen HCEO should demonstrate and deliver. You should see on your screen today's agenda. I won't run through it because I hope you can all read. We will take a break around the midway point where we will take some poll questions. When we do that, I'll explain what we do, but that's how you get your CPD point, by interacting with us at that point. I'm kindly joined today by two rather wonderful gentlemen. Firstly, we have Alan Morgan. Alan joined the National Eviction Team in 2007 after 20 years in senior management and has been with us ever since. Hello, Alan.
Morning, afternoon.
Morning, afternoon. Afternoon,
yeah.
And also joined by David Asker, who is an authorised High Court Enforcement Officer at the Sheriff's Office and the NET.
Good afternoon.
There we go. I'll hand over now kindly to the two gentlemen who will take you through today's webinar.
Thanks for that, Ewan. So to kick off with, who are the National Eviction Team and how do they fit into the High Court Enforcement Group, or HCE Group? Well, the National Eviction Team, or NET as it's known, it's also been known historically as UK Evict. It was established some 20 years ago in its original form by Mike Anderson of the HCE Group. He recognised the need for a highly specialised team of agents to deal with larger and politically sensitive evictions. This part of the business became a full part of the HCE Group during 2017. So I'll now hand you over to David, who will run through some of the different types of possession actions that we can take.
Right, good afternoon everybody. Basically, 7 main types of possession action, pretty self-explanatory. First off, trespass. That includes travellers, especially this time of year. Some of you with rural land holdings and city land holdings will have noticed quite an influx of travellers recently. I know we've been run ragged with them lately. Compulsory purchase orders. That's a frequent source of action for us, especially on some of the larger infrastructure projects. Orders for sale, mortgage repossessions, less likely to be really the subject of the content of this presentation. Commercial premises, non-trespass. Here again, you're not allowed to do the services of the NET on that. You'd have to have some pretty heavy-duty squatters for that. Tenancies and peaceable re-entry. That's on leasehold commercial premises.
So the planning and preparation, what's actually involved? This is generally the stage where I get actively involved, and it's vital that this aspect is given sufficient time, as ultimately it will determine the eventual success of the operation. So breaking the process down, we need to ensure that all stakeholders are involved. These will include obviously the client, but also very importantly the local police force or the British Transport Police, as the case may be. It is essential that we obtain full cooperation from the police, as they will be responsible for any breaches of the peace and also for controlling the public highways that may be near the land or the building that we would be evicting. The reason behind that is it ensures the safety of the public, our officers, and also the illegal occupiers or trespassers themselves. Other potential stakeholders which may or may not be brought into the planning process, depending on the client's desires, could include the social services, the fire brigade, or even the ambulance service, depending on the nature of the actual eviction. The second aspect of the planning, which is vital, is to have clear and accurate identification of the land and premises itself. Always attached to the writs will be a plan of the land, which will be boldly outlined. It is vital that this area covers all of the client's land and also the land that he owns in the immediate vicinity. Well, why was that? Because quite simply, we as authorised officers of the High Court can only operate within the agreed boundaries of that writ. We have no power outside that boundary. So just imagine if there was an adjoining building to the building that was going to be evicted that had not been included in the writ, and we proceeded with that eviction. In the unfortunate situation where the protesters or the illegal occupiers moved across to the secondary building, then we would not be able to take any action on that. Now that sounds as if it's common sense, but believe it or not, that actually happened in North London a couple of years ago, where the client ignored our advice when handling 4 pairs of semi-detached properties. Unfortunately, against our recommendation, they applied and got a writ for 1 pair of semis, and following their request, we proceeded with that eviction. But unfortunately, within 24 hours, the squatters had then moved into the other properties, which resulted in additional costs to the client, having to go back to court to then seek a writ on the remaining 6 semi-detached houses.
And you borrowing my team off me for the afternoon, I recall.
Yeah, we did. Thank you very much for that. The third aspect of the planning preparation is assessing the potential risks involved. And linked to that, that would actually drive the appropriate manpower that we bring to the operation and also the actual makeup of the team. Some of this will be expanded on later, but to give you a little flavour of some of the points that I would consider when assessing the risks, they would include the number of protesters, the makeup of the protesters. Are there any women, children, vulnerable people, or dogs present? The level of police support and their attitude. Any arrest protocol that we need to agree with the police. What would be the best point of entry to the site? Is there a flat roof there? Or are there trees nearby? The level and quality of the police intelligence that we are provided with. Proximity to highways or public transport. Is there a lift shaft present in the building? Do we have full site plans available? Has Sunday working been considered? And that's a very interesting point, because in a longer eviction, an aspect that's often overlooked is the Sunday working. Again, that needs to be addressed at the point of going for the writ, because unless that's actually covered off under the writ, then you cannot work on a Sunday. And I could go on, but for the time being, I'll hand you over to David now to consider the health and safety. And of course, he is my glamorous NEBOSH qualified assistant.
Well, I take issue with the glamorous bit, but yes, I hold a NEBOSH level 3 general certificate. Basically, I acquired that during my 35-year career because it became increasingly obvious that relying on third party for health and safety advice on what is a very, very specialised undertaking, and it had its own problems. So the best way to do it is become qualified yourself. And effectively, what you have to do with health and safety planning is to look at the whole picture, not necessarily from your own standpoint as a landowner, but as to what's around it. There are all sorts of issues that may arise, apart from the obvious ones, which is the usual fear of any hazardous chemicals, any contamination on site, what activities are going on site, what's the geography, what are the weather conditions. There are things in the surrounding area. I mean, there's a case that we've been dealing with recently where the plans for the operation are very much affected by the daily school run. Because whilst the persons conveying their children to and from school are at some distance from the proposed site of operations, I wouldn't be very happy if my young children saw what might appear to be a somewhat violent or potentially violent altercation taking place nearby. And that sort of thing has to come into the planning process. Quite often, health and safety is apparently used as a stick to beat people with. However, the basic premise of it is very, very simple. If possible, where at all possible, you remove the risk from the person. If you cannot remove the risk from the person or remove the person from the risk, then you mitigate the risk. And so far in my career, I haven't come across any sort of situation which we haven't been able to put in appropriate and apt mitigation measures to protect persons, including the protesters themselves, who will sometimes deliberately put themselves at risk in order to delay or otherwise obstruct the eviction. Okay, moving on, recovering vacant possession. How do you go about doing it? Let's start at the easy way first, doing it without a writ, so-called self-help. Trespass on land may be removed by the landowner or their agents using reasonable force, as set out in English common law in Housebridge, volume 45. However, a couple of questions here for the layman to look at. Well, reasonable force. Well, what's reasonable force? Now, that is a question which we'll go into some detail later on, because it is very, very germane to everything we do. Clearly, reasonable. Let's take, for example, let's take a hypothetical situation. You have some land that's waiting for development. It's currently lying fallow and unoccupied, and suddenly you discover that some itinerant travellers, or let's take ourselves back a few years, the good old hippie peace convoy, which this time of year used to pop up on their way down to the southwest. I'm really showing my age now, I appreciate, but this is quite a good example. They pop up on a piece of land, and the landowner will think, well, they'll be gone in a couple of days. 2 weeks later, they were still there, filling the place with garbage, etc. I need to use reasonable force to remove them. How would I go about doing that? Well, obviously, first off, enter into a dialogue. Ask them and say that if you don't remove yourself under your own accord, I will go and get a writ. They don't move, so you engage your agents, ourselves. I'll go down there with my officers, and if they don't show any signs of moving, then it's perfectly reasonable to attach the tow vehicle to one of their caravans and remove it, at which point the rest of them generally tend to see sense and go. Beyond that, I don't think, I've never come across a situation where one's had to use any more than simply more reasonable force than escorting people from the land. Another point to consider at this stage in our discussion of the issues surrounding removing protesters, vacant possession. What is it? Well, now I said the word vacant possession, I've no doubt what flitted through your mind was a nice empty site with tumbleweed blowing across it. It's not always obvious, and we'll describe later in this presentation in detail as to why this may be important. Vacant possession, a good thing to bear in mind for the rest of this presentation. I would define vacant possession, and other authorities far greater than mine would define vacant possession as land which you are the owner of, which you are able to use and enjoy the continued peaceful use of. Bear that in mind, keep that in the back of your head as we continue with this discussion. Okay, court proceedings. Obviously the self-help hasn't worked or isn't going to work, you're going to need a writ. Now, here, the majority, and by the majority I mean pretty much all cases, are heard in the county court. There are provisions in CPR for exceptional cases to be heard in the High Court, but that will be very exceptional, where severe or substantial damage is being done or where there are major risks to public order or health and safety. At the end of this, we'll cover a couple of practical worked examples very quickly, but a good example of why a case will be heard in the High Court was when Admiralty Arch got invaded by anarchist protesters, Easter 2015. It always happens just before I'm going away for the weekend. I got home at 2 o'clock in the morning. That was heard in the High Court because there was a major risk to security and there was damage being done. Okay, well, once you get to go to county court to bring your case to get possession back, what will happen is you'll go through a stage process. It starts with interim possession proceedings. You've got to serve notice of that interim order or notice of the hearing upon the occupants, and that requires them to leave. If after a set period they do not leave, then you can apply for a writ and effectively get the general form of possession in order to enforce it. So, obtaining the writ of possession. Let's assume you've got judgment, okay, you've satisfied the court that it's your land and you have title to it, and there are persons on it, persons unknown or even named persons, or a mixture of the two, Joe Smith and persons unknown. You've obtained judgment. Alas and alack, whilst our courts are highly efficient, they haven't quite managed telekinesis yet. The judge gives the order and often precisely nothing happens. You'll need a writ to enforce it. So, having the judgment, you request a writ from the court issue office using the prescribed forms, the writ itself being a Form 66. That will cost you 66 quid. Now, bear in mind, in my experience, issue offices can take considerable time to prepare and issue the writ. Recent case up in Birmingham, I found myself driving hot foot to Birmingham one Friday afternoon. Notice it's always Friday afternoons, just before the weekend, to arrive to pick up the writ, only to be told that the issue office won't be able to do anything until Tuesday because they were altogether too busy. And meanwhile, there was risk of, because of this particular site, considerable damage, and there was quite a lot of violent argy-bargy going on. This hadn't been taken into account when requesting the issue of the writ. There are things we can do about that. In this, I'll tell you later on what we did here. Once you've got the writ, a bit like Mrs. Beaton's recipe for jugged hare, first catch your hare, you've got to lodge that writ with the authorised officer to whom it is addressed. A writ is effectively, it's a letter commanding the authorised officer to take particular actions. In this case, it will be to David Asker, authorised High Court Enforcement Officer, I command you that you cause the land described in the schedule, vacant possession to be given to the claimants. Okay. And at this stage, we hand over to the good offices of Alan, who, as the official eviction coordinator for the NET, this is where he takes up the cudgels and gets to work.
Yeah, just to revisit the team's responsibilities and whilst forming the operational plan, I'll just run through with you this slide, which basically highlights some of the considerations and work that we will undertake to put the plan together. Initially, the site visit is crucial because that gives us a first taste of what's actually happening on the ground. It'll give us an indication of the dimensions as well and the landscape. This then is an integral part of the initial operation planning process, which we discussed earlier on. Linked to this, we've obviously got to be conscious of regulatory compliance and making use of the standard operating procedures that we've developed over the last 20 years to ensure that everything forms into the orderly plan. The plan is then published and shared with the client and also the local constabulary for further discussion and development. The whole purpose of the operational plan is that it's a living document. We will continue to change and amend as intelligence comes in, right up to the point of entry of the site. And it's really used by the client, the police force and ourselves to improve and fine-tune the whole operation. We've also got to consider any public order risks that there may be in the vicinity and obviously mitigate those, and especially the police would be key to advising us and taking control of that aspect. Managing the protester activities, it's quite possible that when we're on site with the social media being very active these days, that they could actually get further reinforcements to attend the site. So again, the protocol around this in terms of the police involvement and our involvement has to be clearly set out at the very start, because ultimately we are there to maintain the reputation of our clients and of ourselves, and to ensure that the whole operation goes ahead as quietly, without any adverse publicity as is possible. And ultimately, all of this will deliver us a safe operation and a rapid eviction.
So, here I come again, regulatory compliance, best practice of reputational care. Very dry and dusty, but very important. Legislation, legislative issues surrounding the successful enforcement of a writ of possession on land where there are trespassers or protesters or activists. Effectively, it's not, the compliance with that is not at all difficult. It is not the minefield that people think it is. You'll see the second element here, human rights issues, at which point lots of people either run away screaming or fall asleep. And actually, it's very, very straightforward. It's something we've dealt with over the years. There's quite a lot of precedent cases which establish this, and this is taken into account in the operational plan. There's an entire section on that. One of the key issues in human rights issues is that of communication. This will become clear later on in the presentation. Risk management. Now, as Alan said, we arrive with an operational plan. There are contingencies. It is a live document, and it remains live when the operation starts and for the duration of the operation. Risks often foreseen will arise during that operation. Some unforeseen, or not really come across that. We have a staged and phased way of managing those. Effectively, to coin a phrase, a rolling risk assessment is the phrase that's used around our firm. It's the expression I prefer is the one Alan uses a lot. Actually, he calls it a hot risk assessment. I much prefer that because it stresses the urgency. If something happens, okay, what do we do? This is how we handle it. Hazards, I've identified those beforehand on the site, mitigation measures. The plan is key. Yes, we all know that the first thing that goes out the window when boots hit the ground is the plan, but then there's a plan B and a plan C. I always like the Blackadder sort of adage about the cunning plan. Training is paramount. Everybody knows their role. People can work in multi roles. So if you've got an issue on the site that's taking up one side of the site that's taking up a large number of your team, there are alternative members of the team that can step into that role. And most important of all, we work on a no surprises basis. I suppose a lot of you might have it going through your mind, oh great, if you want to remove the protesters, turn up at 3 o'clock in the morning by stealth and pop in. All that's going to achieve is a great big row. The far better method is to communicate warning of the occupants. Now I don't suggest we say, oh yes, we'll be arriving at 8 o'clock in the morning on the 12th, because you might well find you've got half the Red Army there waiting for you. But certainly working on a no surprises basis, that's developed in the plan, letting the occupants know at all times that what is going to happen, that they are going to be removed, or be given time to collect their bits and pieces together. Working on a no surprises basis makes the operation much more controllable and is less likely to lead to problems. And we come on to the use of force. What is reasonable force? Because the fact is, if they were going to go voluntarily, the chances are they'd have left long before you got the writ. So you're going to need to use some sort of force. Now, as some of you have had to endure my presentations before, quite often that use of force is simply having to listen to me. I have known protesters leave just to get away from the sound of it. But on a more serious note, Alan can demonstrate how, for example, when removing persons that need physically removing, how that develops and how it's shown to be reasonable.
Yeah, I'll develop that aspect of it. I mean, it's a major cause of debate is what is reasonable force. We follow the police strict protocol where they use a 5-stage escalation process where we're always seeking the protesters' cooperation and asking them to work with us and remove themselves from the site quietly. Obviously, if they don't do that, then the escalation process kicks in, where every stage is evidenced and recorded by video camera. so that we are seen to be sensible and proportional in our activity. But when it gets to the fifth level, where it's obvious that the individuals aren't going to move away, I mean, basically, you've got two types of resistance. You've got a passive resistance where the individual may just sit on the floor and refuse to get up and walk out. So reasonable use of force in that case, quite simply, would result in us carrying that individual off the site and placing them safely down on a predetermined location. Typically, that would use a minimum of 4 enforcement officers, 1 on each limb, so 1 on each arm and 1 on each leg. And that way we can actually remove them quite safely. In the event of that individual possibly starting to scream and shout and wriggle a little bit, then we'd also look to support the head with a 5th enforcement agent. So that's in the case of a reasonably passive resistance. You've then got the situation where you may well have an aggressive resistance situation. And again, the level of aggression can only be hot risked at that event. But typically, proportional force is what we would look to use. Now, again, what does that mean? Well, we must remember we've also got the power of arrest under Section 10 of the Criminal Law Act 1977, and the protocol for using that power of arrest will have been predetermined with the police beforehand in terms of us making provisions for a handover procedure off sites that they can take over the arrest situation. But to handle that aggressive resistance, we would, and to be proportional and be using a reasonable force, it would mean that we would have to contain that individual. We would not look to sit on that individual's chest, because obviously that could cause a problem, but we would have sufficient resource to stop that individual possibly kicking or throwing punches. And then in the event of having possibly to zip tie his wrists to remove him safely, then that's what we would follow.
I think at this stage it's worth mentioning that there comes to a certain level of aggression where the authorised officer steps in and, using the powers under the Courts Act 2003, calls upon the police to give him assistance in enforcing the writ, because under the Courts Act it is the duty of every constable to assist an enforcement officer executing a writ issued out of the High Court. And this is where you've got effectively a handover of privacy on the site. If you've got the level of violent resistance, and here I'm thinking of particular cases where you've got effectively a mob that's been assembled to physically resist, then at that point there'll be a pre-agreed point where the enforcement agents will drop back, the police officers will step forward, will restore order to the site such that the enforcement officers can then proceed with the eviction. Whilst you might say rendering assistance, you might say to the police, well, I want you to evict them, that is not really an appropriate swapping of roles, and it's all agreed with a memorandum of understanding with the police officers involved beforehand, as Alan's pointed out. Then you have to secure the site. So, Alan, how do we do that?
Yeah, I mean, initially we'd use our officers to secure the primary entry points to the sites to ensure that there's no further protester activity joining or supporting the group that's already within the writ area. And linked to that, the police would be key to that as well, because obviously if a large group assembles outside the writ area, then we would expect the police to take control of any potential breach of the peace. Additionally, it must be remembered that they do have a right of peaceful protest as well.
And this is the point I made earlier about having a designated protest area. You might wonder what that's about. We'll cover that in a while. Yeah,
and securing the site, I mean, just jumping to the last point on the slide there, the post-eviction security site is once the eviction is complete. Obviously, we need to make sure that the site is kept free and empty from any protester or illegal occupier, and that we can arrange the post-eviction security to run on it for a period of time in line with the client's requests. An aspect that we haven't looked at yet is the inventory and abandoned property that's left within the site. I mean, sufficient time will be allowed for the protesters or illegal occupiers to remove their property that they can carry with them, but there may be other goods left, fridge, freezers, cookers, and things of that nature, which they may wish to collect at a later stage. And if the client believes it to be appropriate, then we can actually manage that release
Yeah.
of those goods. But the thing that we always do is that we always will provide a full inventory of whatever's left on the site, and that will be supported by video evidence as well.
And here's where the Torts Act 1977 comes in, because what's generally done where you've got a substantive process site is the authorised officers will arrange for torts notices to be handed to the occupants, advising that if they leave any goods behind, they will be stored by the bailey, the landowner, for a period of time, generally 7 days, very occasionally 14, and they can be collected. Now, generally, we would not recommend you keep them on site. We usually recommend you keep them at an off-site location if we can organise that, and we'll also organise manning a phone line to say, come and collect your goods. Effectively, one of the things that rather mitigates against people leaving goods behind is to point out to them that under the torts notice, if you are going to come and collect your goods at a later date before they're disposed of, then you will need to provide forms of identification. It's surprising how that concentrates the mind wonderfully. Okay, let's go to more regulatory matters. Sorry, chaps, but we do have to cover this. These are in, I would say, pretty much in order of how they occur. Contaminated sites. There goes up the cry asbestos, and everybody puts their hands in the air and goes, oh, this is going to cost us a fortune, oh horror. Actually, in my long experience of asbestos contaminated sites, most of them aren't. Everything around you, every building built before 1986 contains asbestos, but most of it is in a pretty innocuous form and is only hazardous if it's disturbed. I have on occasion, only on one occasion, entered a major London hospital old building, which was squatted by some activists, to find a gentleman halfway up a stepladder with his head buried in the ceiling, removing the copper piping, presumably for later sale, which apparently was covered with asbestos lagging. Actually, it wasn't. It was only tiny asbestos pads between the pipe mounts and the wall. But he wasn't to know that. And I was in a full moon suit with a licensed asbestos inspector. And I said to him, step away from the pipe. And the look upon his face was one of utter horror. Funnily enough, the rest of the protesters left within about 15 minutes. It was probably the easiest eviction we've done in ages. So it can be your friend sometimes. We kind of played that one up a bit. Hazardous locations, all sorts of places, railway lines, roads, bodies of standing water. It's, you know, this is common sense. Quite often we'll use the geography of the site. We will cordon off using Harris fencing, these big metal fencing panels you see. We'll cordon off those hazardous areas, and we'll make sterile working areas. All of it helps us to control the situation and control the eviction process. Vulnerable persons. Those of you who read the London newspapers might remember Parliament Square a few years ago. I always maintained that Parliament Square didn't need evicting. On that night, I think if we turned up with an ice cream van painted purple with Tennant's Special Brew written on the side and handed out cans of said beverage, we would have cleared the place far quicker than we did, because in fact what we discovered there was more than half the occupants were rough sleepers and vagrants and required particular handling. Quite frequently you'll come across on a site women, pregnant women, you'll find children. We will liaise closely with social services in the planning process to make sure that's attended to. We also, all of our officers receive training in vulnerability. We have female and male officers deployed who have a specific role on some of these jobs is to manage vulnerable persons. Violent and otherwise hazardous resistance, we've discussed earlier. There'll be some more detail shortly. Obviously, the regulations that come in under the Health and Safety at Work Act, control of substances hazardous to health, asbestos regulations. Also, a point for quite a lot of corporate landowners, construction design management regulations under the Health and Safety at Work Act. Quite frequently, we'll find ourselves asked to clear a site, part of which is being used for construction. And there's an argument to say, well, look, in this case, it's not being used, it's not a construction site at the moment, but if construction work has started, we may well need to deploy officers who are currently certificated with CDC cards to work on a construction site. Clearly, construction activities cease while in the area where we're doing the enforcement, but this is something we can accommodate. And actions in specialised locations, well, Alan will describe, you name it, we've been there. Power stations, nuclear and coal fire, on the waves, on the land, under the land, up trees, you name it, we've been there, we've done it.
Excellent. So we come to our first break. This is where we find out whether you've been paying attention or not. So you will shortly see on your screen the first poll question, which is, how can you legally remove trespassers from land? Please tick the boxes that applies. The answers you have in front of you are under common law, with the help of the local rugby team, and under High Court writ of possession. Remember, you can tick all the ones that apply. And with 60% of you voted, you are correct. It's either under common law, Housebury's, or under High Court writ of possession.
I hope nobody voted for the rugby club.
Not one person did.
Excellent.
Good start.
It's not exactly hard.
No, we started off easy. Second question, where should the majority of possession court proceedings be heard? Is it in the High Court, in the County Court, or in the Magistrates' Court? And with most of you having voted, 83% went with the correct answer, which was County Court. Isn't in the High Court or the Magistrates' Court, though.
Majority.
The majority.
Yeah. Not your Section 61 travellers either.
Question number 3. Which of the following should be addressed during planning? Please tick all that apply. The names of the protesters, the Human Rights Act, public order risks, reputation management of the client, and where the protesters will go after the eviction. So there were 3 correct answers this time. The first one was the Human Rights Act, the second answer was public order risks, and the third one was reputation management of the client. So for the 41 and the 43% of you went with the names of the protesters, or where the protesters will go after the eviction. You're incorrect.
Although it's interesting information, you don't want them to go next door, but if they do, there's not a lot you can do about it. Most of them are just up the road anyway. Okay.
Question number 4, and the final question for this break, is when evicting under a High Court writ of possession, does notice of eviction need to be served on the trespassers? Yes, notice must be served. No, notice not required. Or 3, notice of the interim order or hearing must be served. And that is interesting. Actually, 52% of you went with yes, the notice must be served. That's actually not the correct answer this time. Notice of the interim order or hearing must be served.
Yeah. You'll recall that's what I said. And generally at that point, with any luck, they leave. If they don't, time for a writ.
So congratulations, 36% of you got that right. Glad you were paying attention. We will now continue on the rest of the webinar.
Right. This is going to be much more of a gather, ladies and gentlemen, because we've pretty much covered a lot of this. As you may have gathered, the Authorised High Court Enforcement Officer is wholly responsible and personally liable for executing a writ of possession. That's why the Office of the Sheriff has lasted more than 1,000 years. Personal liability. It does rather ensure that we are on track with our arrangements. The writ itself confers extensive powers, the right to use reasonable force, and a statutory requirement for the police to assist. And of course, this does extend to criminal offences of obstruction with arrest sanctions, which is useful in the case of a hotly resisted eviction. If, however, you choose to act under common law, it does enable the removal of persons using reasonable force, much as described by Alan, but not up to that level, because you don't have direct support from the police, whose role is to maintain the peace and prevent criminality. And whilst maintaining the police, a police officer could be thought to say, oh, hang on a minute, there wouldn't be a breach of the peace here if you weren't trying to pull them off the land. So maybe you should stop and get a writ. So that needs to be borne in mind.
So just further on the theme of the police, just to confirm it, police responsibility under the powers of a writ, it confirms a statutory duty to assist the authorised High Court enforcement officer. So they have got a legal obligation to support us in the enforcement of the writ. That doesn't actually mean that they actually come on site. We have primacy of the site unless things get out of hand and we have to withdraw and we hand the primacy over to the police. Common law, the police have no role apart from keeping the peace. They may even decide not to turn up because they may not see it as a problem for them. So you need to bear those two distinctions very at the forefront of your mind when deciding whether you go for the common law approach or for the writ approach. We've already discussed the operational planning exercise in terms of the way that we've done it and with the experience that we've acquired over the years, both in conjunction with different clients and different police forces, and also with the health and safety executive. So again, that's very much seen as a formal memorandum of understanding between the key stakeholders and is the basis of the operation. And let's have a look at an operation now. David, do you want to speak to
Yeah, very quickly, I'll go through Bexhill Hastings Link Road, where you had organised protesters, local people in the main, and this was a successful, long duration, 11-month protest management operation. And the thing here is, the key word is protest management. It started out as a lot of obstruction to construction work, so starting on the site by people up trees, down holes. So we had to deploy climbing teams, a tunnelling team. The key to it was planning. It was done in a several series of stage day operations, and the key was communication with the protesters, not the least. On the no surprises basis, they realised after the first couple of days that actually they weren't dealing with a bunch of what I call no-neck monsters, you know, the gentlemen with shaven heads and no necks. This was a disciplined, organised force, and in fact, on one particular morning, the temperature dropped to -15, and I took the decision that it would be hazardous to continue. We had welfare facilities on site, and there were a couple of protesters who, were issued with thermal blankets and given a couple something more. It's in nobody's interest if anybody gets ill on these sites. It does nobody's reputation any good. It also served to build a decent rapport between ourselves and the protesters. As a result, operations after eviction operations were completed in 2 months, and the rest of the duration of the operation was simply almost policing and managing the protests in a designated protest area, and making sure that construction works could proceed, and from the client wanted the ability for the protesters to be able to protest and be seen to protest, and that was largely managed. So it shows you that this sort of case study shows you that these operations aren't necessarily what they might have first seen. There are some complexities there, but we are well versed in handling these from soup to nuts, really. Designated protest area. I just mentioned that. What the hell is it and why? Well, take an example of on a fracking site where in fact, the judge in the case said, was there an area where these people could protest? And when the answer came back, no, there isn't. Well, it was come back when you've got one. Now, in this case, people were saying, well, we better put a designated protest site, it's along a roadside, somewhere up the road. The point I made was, if you were a protester, you wouldn't be very happy with that. And there is no reason why the designated protest area, protected from vehicular traffic, travelling at well over 60 miles an hour down this road, close to a commuter station, so the evening period was a hazardous one when they're all rushing to get home, behind safe Harris fencing, right opposite the entrance. There were hay bales there to protect them from any impact. Of course, this did mean that it made it quite hard for the protesters to leap out and get into the road and block traffic, but it also protected them from the traffic. The point is, there was an arrangement made where they could hold a lawful and legitimate protest in safety. It kind of takes the wind out of people's sails on our various arguments about suppressing lawful protest. Specialist access teams, we've mentioned this. Alan will go into some detail on this, the safety issues and risk mitigation around those specialist access teams. I'll leave to my esteemed colleague.
Specialist access teams basically revolve around working at heights, whether it's trees, towers, chimney stacks, anything above ground effectively. I mean, the guys that we used were all IRATA 3 level climbers who are basically considered to be the elite amongst the climbing fraternity. We've also got the lock-on team then that will have specialist tools and specialist training to ensure that they can remove people using power tools and rotating blades to get them out of concrete blocks and various other bits of metal, barbed wire, rubber tires, anything that would cause us to delay the eviction. Highly specialized guys who have years of experience behind them. And the other team that is particularly skilled is the tunneling team, who are highly qualified in dealing and assessing risk assessments underground, including measuring the oxygen levels and actually communicating with underground protesters, which is a skill all to itself. Again, these situations, the guys all are experienced in hot risking the issues ahead of them, and in the cases where these removals are proving difficult, we would always operate on a slow time basis and take our time, reassess the position, and work progressively at a very measured pace to ensure the safety of both the enforcement agents and also of the protesters.
And quite often protesters will put themselves in the position to deliberately put themselves at risk. I mean, springs to mind Alan's experiences with protesters using D-locks to attach themselves to trees. I had a personal case of that recently, and here there was, oh dear, we've got a protester up a small tree who's attached themselves to the tree with a D-lock around their neck. If we try and move them, oh, that could be difficult. Well, here you turned it on its head. Rather than remove the protester from the tree, we chose to remove the tree from the protester. So the small tree, complete with protesters, was loaded to the ground, and whereupon the top was cut off, the bottom was cut off, and I asked the question I never thought I'd ever ask anybody ever: would you like me to remove that tree from your D-lock? And the answer came back yes, so we did, and he left the site. Shortly thereafter, was escorted from the site. So again, here it shows that slow time is sometimes necessary. Now, clearly from this, you'll see that we have to liaise very closely with police and emergency services, ensuring the right resources in place for the enforcement, and of course contingency plans. What happens if there's an issue? And as I mentioned earlier, welfare provision for all persons on site. That's not just the enforcement officers, that includes the protesters.
Quick story on that one. I know we're running out of time, but it's worth mentioning. There's a situation in south of Glasgow some years ago in January. They just had about 3 or 4 foot of snow up there, and we were there the following week. And 2 young ladies decided to protest up a 25-foot tower, probably some 600 meters off the roadside in some quite boggy land. We were unable to get a suitable vehicle up there or a cherry picker up there to actually get to their level. The actual building itself was considered, or structure was considered unsafe, so we needed to get the vehicle up there. They'd also, unfortunately for them, got their wrists tied in a rabbit snare, which meant that they were unable to release themselves, which resulted in them having to spend the night out in sub-zero temperatures until we could get matters sorted out the following morning. Now, as part of the duty of care and protecting the protester, that involved making sure that they had sufficient hot teas and coffees and sufficient blankets and covering for the night. Otherwise, they would have suffered considerably.
Okay, Human Rights Act. This is a quick gallon through this because what's on the screen is what it is. The applicability, you might say to yourself, well, hang on, I'm not a local authority, I'm not a major corporation, I'm not a statutory body, therefore it doesn't apply to me. But one could argue the writ comes from the High Court of Justice. It does apply, and it's common sense anyway. What it requires is what sort of financial interest in the property is there, what interest does the occupant have in the property, is there trespass or damage going on, are there named or unnamed persons, is the person on the land free to pursue their activities, and how does that stack up against the landowner's rights to enjoyment of the land, clearly, in the case of an enforcement action, it stacks up against the illegal occupant who is removed. The point is, the Human Rights Act requires a period of negotiation that is entered into. Effectively, we make sure that that's managed so there can be no delays to the eviction through any attempt to say that somebody's Human Rights Act are being violated and applying for a stay of execution. Proportionality, this is the vital thing. Any action we take must be proportionate, lawful, properly authorised. That is all the boxes very easily ticked. The operational plan ensures that actions we take are proportional and are demonstrably so. A period of negotiation is entered into, that is demonstrated. There are occasions where, to enable people's rights to be protected, they may need subsequent access to the site. We've spoken very briefly about retaining their property, recovering their property using tools notices. Again, there are some specific exceptions. There are occasions you might be faced with a large eviction where someone that you evicted needs to come back on and collect something. I thought somebody left their medicines behind. One occasion in Holborn, some poor chap came to me in tears. He'd left his entire university degree dissertation in a bag somewhere in the building and had lost it. It took us an hour and a half before we found it. It's in nobody's interest to say no, go away. It's far better for all concerned. Jaw, not war. Hence the point about controlled access.
Okay, communications during the operation. Essential part, both communication between the actual enforcement team and the respective teams within that setup, communications between myself and the client, regular updates for the client and for the police, and also briefings following the event, because we always have a briefing with a client following the event in order to establish best practices moving forward. One aspect to cover quickly as well is media communications. That's generally decided by the client's policy, and they usually take charge of that aspect of things.
One thing that occurs to me at my age and after 35 years, protest community legal observers. What's that, you think? Well, quite frequently you'll be faced by the protesters saying, look, we've got these legal observers, and there'll be chaps in high visibility jackets with legal observer on the back. You might at first be tempted to say, be off with you, but actually they can be a very, very useful source of two-way communication, diffusing tensions, making things happen. Generally, we'll permit one under strict rules that they'll be attended by an enforcement agent at all times, that they stay away whilst they can observe what's going on, because we want to be completely open about that. Whilst we have evidence going to film everything, this always helps. Sign at my age is I found myself a few years ago at Bexhill actually standing next to a chap, tall bearded chap, and he was quite upset with the activities of one of the tree protesters who was busily engaged in doing what monkeys do and throwing certain objects down out of the tree. And he said, oh, never have done that. And I looked at him and I said, you were at Newbury, weren't you? We suddenly realised that we'd met in a tree on opposite sides many, many moons ago. But that actually helped the communication process. It could certainly make for a much smoother and safer eviction.
So finally, back from my perspective, the deployment and resourcing, to quickly run through this. Yeah, the deployment numbers is basically agreed between the client and myself, and also following the police intelligence reports and risk assessments, what the numbers will be. That then forms part of the original operational plan in terms of a full costing for the anticipated duration of the eviction, whether it's a 1 day, 2 day, or further longer eviction. Part of this also would include the overnight security, and also possibly in the case of the tunnelling team where they'd operate 24/7 across 2 teams to make sure that the job is finished off as quickly as possible. All of that would be decided at the very start with a client. In terms of post-eviction work, which may include the restoration of the site to its original state, which we've had to do on 1 or 2 occasions, whether that means clearance of all the wood and all the rubbish and all everything else that's been left on the site, then we are more than happy to look and actually provide that service as well.
Recent operations, I'm not going to go into huge detail, most of this you can find on the internet. One of the things that can really ruin everybody's day is protesters off the site. Now that photograph you're seeing there is some of 300 freemen on the land who turned up to protest somebody being evicted by the county court. My involvement was simply, we were asked to provide the eviction security and post-eviction security and the resourcing to manage protecting the county court bailiffs going in. It wasn't my writ. In this case, we found ourselves in a situation where you have to control a whole area of land over which you've got no powers. And here, the agent with the police was key. It shows you the sort of thing that can happen. It's nothing unusual to us. That was dealt with quite successfully. They'd had 2 prior attempts at the eviction, which have been forestalled by the presence of protesters. We did it on the day. 300 turned up. It went ahead. Somewhat unfortunately, the police communications failed. So instead of sitting in a nice warm control room wearing my black suit, I said, well, if your controls have failed, we'll have to go and do it from the curbside. Unfortunately, everybody assumed wearing my black suit that I was from the bank. And I spent the entire day being spat at, which was an interesting experience. We've done various fracking sites, marine sites, Admiralty Arch I mentioned earlier. Rapid response is the key there. Yes, you can get in front of the High Court and get an emergency writ, and we can attend just as quickly. CPOs, we've had lots of cases where you've got tower blocks with lots of people in them. You've got to deal with a CPO. It takes weeks of planning. Communication is the key here. And Bexhill Hastings Relief Road, I mentioned earlier. Balcombe fracking site, I mentioned earlier with the safe protest area. We've also worked on certain nuclear new build sites. Their reputation management is paramount, and it's a case of a low-key, if necessary, extended operation.
Smashing. Thank you very much, gentlemen. So we will have our final 4 poll questions, which we'll get right into. Question number 1 will be, who is responsible and personally liable for executing the writ of possession? You should see that on your screen now. Smashing. 90% of you were correct, and that is the authorised High Court Enforcement Officer.
Yep, I carry the can.
Second question. What is the role of the police during the enforcement of a writ of possession? Is it to prevent a breach of the peace, to assist the HCO when requested, or to record the eviction for evidence gathering? And we seem to have a fairly equal split between to prevent a breach of the peace and to assist the High Court. But the correct answer is to assist the High Court because it's under a writ of possession rather than under common law. Question number 3. In order to comply with the Human Rights Act, any action must be proportionate, lawful and properly authorised. Is this true or false? And you are all correct, it is true.
And the toughest question we've left till last.
If a protester has deliberately put themselves in a hazardous situation, to what extent is the authorised HCEO responsible for their safety? Minimal responsibility, the protester accepts the risk. The HCE is responsible with protective measures in place for all, or the police social services are responsible for the protester's safety. And you are correct, it is down to David.
Yep, it's down to me. That's as it should be, though.
So to wrap up, guys, we've got a few questions which we will rattle through for you very quickly.
What I will say with the questions is, because we've had so many questions, if we don't answer your questions this session, we will email you the answer. We're a fairly small community here, so that shouldn't be a problem. Give me a week or 10 days and we'll get answers through to all of them out to you.
So if we have a look at the first one, if you're enforcing a CPO, do you need any other court order to take action?
Oh, interesting technical one. Compulsory purchase order made by a statutory body such as a local authority. They have the power to make compulsory purchase order. Do I need any other court order? Not court order, no. But I will, if you want me to go and enforce the CPO, I will need a warrant from that statutory authority commanding me to go and enforce the compulsory purchase order.
Next question. Would you get social services involved before the eviction if you knew there were children present?
Why wouldn't you? I can think of no circumstances, and even if you don't know there are children present and you find there are children present, Most local authorities, social services, if you're going to do an eviction where you think there's likely to be, you'll tip them off. They may not send somebody, but they'll give you a number to call. The police are excellent with their communication on this. It just isn't an issue. And we have trained officers, male and female, to deal with children and other vulnerable persons.
We'll do two more. What is your response to a squatter who says he has a fundamental human right to housing, with freedom from forced eviction, and that you're breaching his human rights by evicting him?
Entering into dialogue with said person, because you never dismiss that sort of comment. The landowner also has a right to peaceful enjoyment of their land. We have entered into negotiation with you before you've been asked to leave. You've been told why you're being asked to leave, and should you not leave, yes, we will take action, but that action will be proportionate. And as Alan described earlier, you're asked for 15 minutes to pick up your stuff. I need you to leave. If you then sit down on the ground, you'll be carried out. If you lock yourself on, we'll bring a specialist team in to remove you. It escalates, but it's proportionate every time. There is no question of anything else.
And then the final question is, what is the most challenging situation you've ever faced?
Well, apart from getting up this morning, I think the best challenging situation ever faced, I would have had over the ladder on this one, because you had the girl down the tunnel who had the rabbit snare around her neck. Was that one of your jobs? It was, wasn't it?
David, I'm sure you're making that one up, but I will come in with one. It was on a traveller site, which you'll all recognise as Dale Farm. There was an old vehicle where 3 protesters had locked themselves onto what was a very complex lock-on under the back axle of the van. There were 2 bodies coming out from either side of the axle and one at the back end, which meant that we couldn't pull them out or extract them. The actual tubing, steel tubing that they had their arms in, they were caribed in the centre, so they couldn't actually release themselves. That was backfilled then with concrete, and which was then wrapped around by tyres under a rolling trolley, or trolley with wheels rather. So effectively we had to strap the van, because we couldn't physically move it. We have to lift the van up, and then we had to drag the 3 in unison out from underside the van, and then we literally had to chip away at the surrounding debris until we could actually get to the metalwork, at which point we cut them out of the lock. But that was the most challenging I've come across.
Yeah, I mean, what I've seen was somebody who got themselves in trouble at the top of a tree. Had to be got down to an aerial rescue, which took about 15 minutes to do. And there, the problem was getting the stretchers up the tree. And I will say this for the protesters: all but one of them assisted the rescue team in getting the stretchers relayed up the trees and get the team down. The one that tried to resist was set upon by his comrades, so we had to go and rescue him. But there we are.
Excellent. Well, I think that will wrap everything up. My thanks to both Alan and David for coming in and taking part today. We will be sending out all these slides, CPD certificates, a copy of the recording will be sent out to you in the coming days. We will then also do a follow-up for any questions that haven't been asked, which we'll send out to you as well. If you've got more questions, don't hesitate to contact us. We are there to help. There is also a feedback form. It's really, really helpful to get your guys' feedback. We do put in a lot of effort and time into making these webinars run well, and if we can make it better, we'd like to be able to do so. So thank you very much for attending and for listening. And you're all still here. We do apologise for running over by 5 minutes or so, but we hope you found it helpful. That's goodbye from me. Thank you very much.
Thank you very much.
Thank you. Goodbye.
Cheers, guys. Take it easy.